Welcome to the Melinda Eitzen Show. I'm Melinda. Today I have with us my wonderful partner, Vanessa Sheppard, and we're going to talk to you about mediation.
Yes.
Welcome!
Thank you so much, Melinda. Thank you for having me.
I'm so glad you're here.
Of course, happy to be here.
So, mediation.
Yes.
In case we have a listener that doesn't really know what mediation is, or they've heard of mediation and arbitration and things like that, give a little brief definition.
So, mediation is a settlement process that involves you and your attorney, should you have one, and the opposing side and their attorney, should they have one, meeting in separate rooms where a mediator who would be elected by both parties would go between both rooms and negotiate and try to reach a mediated settlement agreement, which is the final agreement you will sign at the conclusion of mediation that will resolve your case in its entirety. That's the goal.
And how does mediation differ from arbitration?
So arbitration involves an out-of-court process where you present your case to a third party who is a final decision maker. Mediation and a mediator facilitates an agreement between the parties. So the goal is that you both work together to agree, whereas arbitration, you're presenting your case and you have a final decision maker.
Okay, so the mediator is not a decision maker.
Not a decision maker.
They're helping, though. They're
Yes.
helping the two people see maybe some common ground.
Yes.
How many cases, or do most cases go to mediation?
Yes, surprisingly, about 90% of cases do go to mediation, and the 10% that don't go to mediation, normally they resolve outside of court regardless. It's very few cases that actually go to a final trial.
And some courts require people to go to mediation.
Yes, it is usually required in the courts in the DFW area that you attend mediation before final trial.
There's even one court who won't even give you a trial date until you have not only scheduled, but attended mediation.
That's absolutely correct. So that's very important.
Some will allow you to go to trial without mediation, but they shorten your trial time.
Yes, they usually give you an hour total to try your case, which is 30 minutes aside, which is not a lot of time.
No, it's not sufficient.
No.
And the reason I think that courts want us to go to mediation is they're busy. They can't deal with all these cases, and they want us to settle, and it's a very successful process.
Yes, I would absolutely agree with that.
What makes for a successful mediation?
I will say preparation is absolutely key. You're not showing up to mediation, the day of mediation, trying to figure out what your bottom line is with your attorney. The goal is that you meet with your attorney several weeks in advance. You come up with a strategy for what you want to ask for at mediation, figure out what your goals are, what your bottom line is, meet with your attorney to figure out what assets and liabilities comprise a community estate, how you want to handle time with your children, how you want to handle decision-making for your children. So it's very important that you meet with your attorney prior to mediation to discuss these goals and have your attorney work with the other side actually to distill what the issues are going to be at mediation. Because if you show up to mediation having no idea what your goals are, then it's probably not going to be a very successful mediation.
And it's not an inexpensive day, right?
Correct.
They're paying the mediator. They're paying both of their lawyers. So we want it to be as productive as possible.
Absolutely.
Well, from a mediator's lens, I like it when people are prepared. It makes my job easier. But I see the wide range. I have some that are super prepared, maybe even over prepared. And then I have some where they come in and I say, so do you have a settlement offer ready? And they say, well, let's see. They have a house and they start listing for me.
Yes.
No, the property, like I am creating a list. Most people, though, hopefully somebody, one side or the other, has created a spreadsheet.
Yes, the
on the
spreadsheet
property
is
side.
key when there's property disputes going into mediation. The spreadsheet is absolutely important. And for fellow practitioners out there, make sure that the spreadsheet reflects all the assets and liabilities. It's very important to have that conversation with your client to make sure everything is encompassed and make sure that the spreadsheet is a workable spreadsheet that you can edit and that you understand the edits that you're making to that spreadsheet as well, because you don't want to accidentally input a wrong value or subtract when you should be adding, or adding when you should be subtracting, and then coming up with a wonky property division at the end.
And that is the challenge of using someone else's spreadsheet. So in mediation, often I'll have both sides have a spreadsheet, and we often end up adopting one, which is efficient, right? Instead of we're trying to use two spreadsheets all day. But the caution is, to your point, if you didn't build the spreadsheet, you don't know how they built it. And you can tell, you can just click on the cells and see the formulas. But one example is you could be putting your liabilities in as a negative number each cell, or you could be just taking that calculation and then subtracting it from another number.
Correct.
And if one person took one methodology, they're just adding them all up and later subtracting, and then the other person came in and put negative in there, now we have a double negative.
Which we want to avoid.
Right. So people do need to be thoughtful about making sure, if they're not sophisticated in building spreadsheets, they just want to take the time to check in mediation if they're going to use the other person's spreadsheet, or maybe don't, if
Right.
you really aren't sophisticated enough to sort that.
Right. And again, it's very important that as the client, you meet with your attorney to confirm that the values are correct, to confirm that the assets are completely listed, that the liabilities are completely listed, and that you're working off up-to-date numbers, right? Because
Mhm.
if you prepare a spreadsheet 8 weeks before trial, then
Things have changed.
things have changed in all likelihood. So it's very important that you meet with your attorney shortly before mediation to update those values, to make sure that you're, again, working off correct values at mediation.
It would be a great practice if everybody scheduled time, at least with the paralegal and the client, the day before mediation, to make sure you've captured all the screenshots of the latest,
Yes.
right? For the things that are changing all the time, bank accounts, credit card balances, that kind of thing. But to your point of planning ahead, there are some things we can't just look up live, right? Like, we might need to hire somebody, evaluator, to go value something or appraise something.
Yes, absolutely. When, for example, the value of a house is in dispute, it's usually best practice to hire an appraiser to come formally appraise that real property and come up with a value that neither you nor the other party can really dispute, because you have a third party expert coming up with a value independently who's objective, that has no dog in that fight.
Mhm.
So, and that same goes for any separate property counts that you're trying to allege your separate property. It's very important to get an expert involved to make sure that the value of that account is accurate, that community interest is being taken into account. So you might definitely have to hire third parties to make sure that you're working off correct values in terms of mixed accounts or real property.
I like what you said about you would work with opposing counsel ahead of mediation. And the reason that that could be important, and one error that I have seen, is an over reliance on everyone's inventory and appraisement.
Yes.
And, as you know, we often swap a listing of assets and debts called an inventory and appraisement. But sometimes those have not been thoughtfully created.
No.
And somebody will put a value that they didn't really think about, they don't really adopt. And then at mediation, the other side will say, well, I relied on their number. So if you really can even publish your spreadsheet, maybe not with the settlement aspect, but just the values to each other ahead, and say, hey, are we both on the same page about this number?
Yeah.
It helps, because you can't, while you're sitting in mediation, get somebody to run over and appraise the house.
Correct. That would not be a wise use of your time, your attorney's time,
Mhm.
or the mediator's time. You definitely want to come prepared. And it's important not to think of opposing counsel as opposing counsel.
Yeah,
For
we should probably
mediation to-
change our words.
Yeah. For mediation to be fruitful, you have to think of it as a team effort at that point in time. Obviously, if mediation fails, and you're in a whole different dynamic
Back
at
to
that point.
opposing.
Yes. But it's very important to make sure that your values are matching up. And if you don't have matching values, that you figure out why they're so disparate, if at all. So it's very
Mhm.
important to have that conversation. So mediation, the last thing you want to do is be doing discovery at mediation.
Right. And that does happen. We do have situations where we are doing some discovery, and that's okay. I mean, I think the push pull is people don't want to spend so much money that they're ready for trial,
Correct.
because one benefit of settling is avoiding some of that cost,
Absolutely.
but they have to do enough to settle in a way that's advantageous to their client.
Absolutely.
Give another example of that.
How do you mean?
Well, what's something that you might really not choose to do on purpose because you're hoping the case will settle and you never have to do it? Like you mentioned tracing, maybe talk
Yes.
more about, do you really want to always have to do full tracing for mediation?
Absolutely. And I think that's on a case by case basis. Certainly, if you have a significant mixed character property, mixed character meaning that it has some community assets in it and some separate property assets in it, then depending on the size of that asset, you may want to have a forensic accountant do the tracing. However, if it's a small asset, there's not a lot of community interest in it, I don't think it'd be worth the client's time to do that tracing. So it's really on a case by case basis. Of course, if mediation, unfortunately, which never really happens, fails, then at that point you can ramp up your preparation for the litigation aspect of your case. But the tracing, it really depends on the size of the asset and how much it means to you to have that asset confirmed as separate property or how much you're willing to compromise on that issue.
Yes. And we do have experts in town who will give you a quote.
Yes.
It's really based on the level of documentation they're going to have to go through and how heavy the trading is in the account, that kind of thing.
Absolutely.
But often you can give a sampling of that to the expert and they could say, okay, I think this trace would cost XYZ.
Yes.
And I'll tell you, I have had in mediation, some people say, you haven't made the trace, I'm not recognizing $1. Like they're just stand firm on that all day. And then I've had other instances where people say, yes, he knows that that was really her grandmother's gift to her, or he knows she had worked at that company prior and that some amount is there and we'll recognize some, and with either very little proof or no proof. So you don't know which you're going to have in advance unless, to your point, you have talked to opposing counsel.
Absolutely.
So that's a perfect example. How hard is it to have a phone call and say, hey, are you going to hold me to strict proof to recognize any of this? Because we're going to think about, do we need to do it or not? I don't want to waste everybody's time and money doing it if your client might be more flexible.
Absolutely.
And recognize some of it.
Absolutely.
It's their money too that's paying for the trace.
That's true. It's all
Community
coming out of the
property.
community. Yeah.
So that makes it a little tricky. But this all requires thoughtfulness and planning ahead.
Absolutely.
Think about what's the best timing. Like we filed suit, we do or don't have a trial date yet. Where's the best timing for mediation to occur?
I honestly think after the exchange of inventories, so you have an idea of if there's community issues or property disputes, what the property, community estate, and separate estate are comprised of. If there's children involved, then at that point, my recommendation would be to try and enter into agreed temporary orders, see how whatever visitation schedule gets worked out, decision-making schedule that gets worked out, see how that works, because at mediation, to be fair, you can enter into agreed temporary orders at mediation as well.
That's true.
But for mediation, you have to recognize that you're entering into a final agreement, which once it's signed is binding and irrevocable. So the final order in that case must reflect what's in that mediated settlement agreement. So you want to be sure that you're coming into mediation armed with as much information as possible. If the current schedule isn't working, you don't want to agree to that at mediation. If your income has changed and the child support that you're paying is no longer within guidelines, you don't want to agree to that amount at mediation. So I think mediation is best held after the exchange of inventories, after there's been a trial period regarding the kids and the decision-making and the visitation and the child support, but certainly well enough before final trial, because the Texas Rules of Civil Procedure, for example, require you to designate your experts 120 days before trial. So if you do have to get a forensic accountant involved or an appraiser involved, you want to leave sufficient time to do that. So I would say smack dab in the middle, depending on what your case timeline is.
You made a great point. It's important that mediated settlement agreements are binding. And that's part of the selling point of mediation is if everybody signs, somebody can wake up tomorrow and have buyer's remorse, but too bad. And that is not true for any other agreement before a judge signs it. So if we just sign an agreement that has not been through mediation, somebody can change their mind tomorrow.
Absolutely. So that's a beautiful part of mediation and the scary part about mediation because you're locked in. And to let our viewers know, mediation is a completely confidential process. So if mediation fails for any reason, no one can go to court and say, well, Sue offered me this at mediation. Well, Tom offered me that at mediation. It's a completely confidential process. You can't subpoena the mediator to ask the mediator what happened at mediation. So that way you feel free and open to make any offers that you feel would be in your best interest, your children's best interest. And that way, if it gets rejected, no one's going to come back in court and try to use that against you.
Yes.
So that's also the beautiful part of mediation is it's confidential. And if you reach an agreement, it's binding. So the negotiations in your case are over with at that point.
The only thing we can tell the court is we mediated or we didn't.
Absolutely.
And we settled or we didn't.
Absolutely.
So you don't get to say who the problem was.
No.
If it hadn't been for so-and-so, we would have settled this case, Judge. You don't get to imply or suggest anything like that.
No, you do not.
So and that's important because we want to be free to brainstorm,
Yes.
have a bad idea on the way to a good idea, and not worry that it's going to be held against us.
Absolutely.
So that's a powerful part. Okay, so are most cases a full day mediation, a half day, more than one day? What's your opinion?
D, all of the above. So I personally prefer a full day of mediation, especially when there are kid and property issues involved, because you don't want to feel, or you don't want your client or you as an attorney to feel rushed into making a decision. The more time you can allocate for yourself, the better you will be. And there's some mediators nowadays that offer semi-full days. There are mediators that offer half a day, full day, and then there's some that offer 6-hour mediations. So you would there's a wide range of times you can ask a mediator to mediate your case. But if the issues are narrower and the scope is really limited, then you don't need more than a half day to mediate your case. So, and there are cases with very complex issues, numerous businesses involved by the parties, for example, a significant estate, more complex children issues. Those require multiple days of mediation because, again, you want to allow yourself the time to brainstorm, to figure out what's at play here and to figure out your client's bottom line, which again, you hope to know before going into mediation. But during mediation, that bottom line can change depending on what the offers being made or what the offers being rejected are. So,
and typically in my experience, I am doing more and more multi-day as the mediator, but usually they're not scheduled back to back. So we have a day of mediation today, and then we all look at our calendars and pick a day to come back. Because sometimes one reason we need to come back for a second day is they're going to gather a little bit more information.
right.
So maybe they weren't as prepared as you're describing, and they realize during the mediation that it's a huge issue, the value of this house, and nobody's gotten in a brace. And they agree, okay, let's go take that step. And that'll take a couple of weeks. So then we schedule a day to come back.
Yes. And to note on that note, if you do multiple days or a half day or full day or a semi-full day, just keep in mind that no, you don't get to go home and sleep on the agreement. If you have an agreement at mediation, 9 times out of 10, you're signing that agreement that day. So keep that in mind. Obviously, make sure to carefully review the mediated settlement agreement, review it with your attorney, make sure you understand it, make edits if need be. But just be prepared that at the end of that mediation, if you have an agreement, you're signing that day. So 9 times out of 10, that's the case.
And you're kind of speaking to people worry if they come back a second day that we'll have backsliding.
Right.
So whatever we've already had a court on, or we think we have, if we haven't signed anything yet, people could say, I thought about it, I don't agree to that anymore.
Correct.
But you hope that we won't have much backsliding.
Yes.
My experience has been, because of course we all worry about that, my experience has been that on the whole, we do not have heavy backsliding.
That's great.
Which means that it was a good agreement. When you have backsliding, it's probably because somebody did not enter into an agreement, and they haven't signed anything. That was a good agreement. It wasn't going to withstand and hold, and they would regret it. So if you have backsliding, you do. Sometimes, people shop around their ideas to too many people.
Yes.
Causing backsliding. But usually we don't have heavy backsliding. So that is the good news about that, because that can be a concern. Okay, I told you before we started, I'm going to talk about something that happened yesterday in one of my mediations. Because every mediation is an opportunity to say, oh, they did that really well, and oh, that wasn't so great. The challenge to not working with the other lawyer ahead or not publishing an offer, and I get that people have reasons they don't want to publish an offer ahead, and there's some valid reasons. But when they don't, you're asking the other side to digest a lot of information quickly. And in the instance I'm thinking of, they brought in, 25-page parenting plan that was very unique, very customized, very detailed. And the other side just could not digest it in that 1-day setting. And that really caused us delay. So even if you do that, which I could see merit for, like you're thinking through the details, your client cares about the details, you want your client to fully understand it. This means it's Wednesday at 2:00, there would be a transition, da-da-da-da-da-da-da.
Right.
There's a purpose for I could see a purpose for doing it in advance. But then my advice is, then boil it down to a 2-page bullet point.
Right.
Because people can't digest that. They're not going to sign a 26-page. It's like bringing the whole decree, which some people do also.
That's true.
And saying, sign the decree. No one does that. I've never had anybody sign the decree in mediation.
No.
I see why they love the efficiency of it, but you have to then put it in a shorter form.
Absolutely.
So people can understand it and read it.
Yes. Absolutely. That's very important. The understanding and reading before you sign the MSA are key. And usually at the end of mediation, I can understand everyone's tired.
Yes.
It's been a long half day, full day, semi-full day.
It's emotional.
It's very emotional because you're making life-altering decisions in that, honestly, in that short span of time. So it's very important that you do take the time and the energy to really digest what you're agreeing to before signing it, and making sure that when you're going into mediation, that you've alerted your attorney again to what your bottom line is, which can change, but it's just important to be on the same page with your lawyer. So that way the day can be that much more efficient.
We use a lot of terms that are familiar to the lawyers, but of course it's the client's first time to go through this. We say standard possession, expanded standard possession, rights and duties, JMC.
Yeah.
There's so many terms that we use, guideline support. What do you do so that your client isn't having to learn all the terms live at mediation?
So usually I sit down with my client and having that mediation goal conversation with them, I ask them, what is your ideal situation? What is your best day in court look like? And they usually tell me XYZ. And then I say, well, just consider that you're entitled to an expanded standard possession schedule, for example. And then I explain what the expanded standard possession schedule is. And I usually follow it up with it in writing because it is a lot of information to digest over the phone. A lot of my clients benefit from seeing it broken down in writing. Guideline child support, I talk with my client about, what are you making? What kind of income stream do you have? Are you commission-based? Are you W-2? Do you work hourly? Are you salary? So it's important to have these in-depth conversations with your clients and then explain to them what a court may do, what the Texas Family Code requires, and what you can agree to or negotiate at mediation.
Mhm.
So it's very important that because you don't want to be bombarding your client at mediation, agree to an expanded standard possession schedule. And they're like, I don't know what that means.
Right. Or somebody says, oh, let's do standard holidays.
Yeah.
So I like to publish, like, literally just the language out of the family code to my client and say, hey, this is the standard holidays. Study on this so that you understand it ahead. And then let's have another conversation
Yes.
ahead so that when somebody says, oh, let's just do standard Thanksgiving, you know what that means.
Right.
And we don't have to waste a lot of time defining things in
Yes.
mediation. I do. I mean, I'm defining them all the time for people because I can tell nobody's explained it.
Yes. Which is unfortunate.
Yes, yes. And it's just a little bit of a time waster, which I'm there for whatever they need, right? I mean, if they want to spend 4 days with me and I'll define every term in the family code, I'm happy to do that. But it's not cost efficient.
No.
So we're trying to talk today about how can they do this in the best way to get the best result with the least frustration.
Yes.
One thing that clients like is they can do mediation in person in separate rooms,
True.
but we now do a lot of them on Zoom.
Absolutely. And I found that Zoom mediations are equally as effective as in-person mediations. So to clarify for the viewers out there who don't know how a Zoom mediation would work, Zoom mediation essentially means that you'd be in a breakout room with your attorney and the other side would be in a breakout room with their attorney. And the mediator would pop in between both breakout rooms, proposing offers, counter offers, and facilitating an agreement. So, and you can go to your attorney's office and sit in via Zoom with them. The opposing side is welcome to do the same. You can take it from your house or any other place where you feel comfortable. Of course, make sure it's a place with enough privacy that you can discuss these personal issues in a setting in which you're comfortable and there's no obstruction in terms of noises or people interrupting you. And another point, please, please, please do not have third parties present at mediation unless the other side has agreed to them being present. So it's very important that you are the sole decision maker that day, along with your attorney who is advising you. But at the end of the day, the decision is yours, whether to enter into that agreement. So it's very important that you take charge of this situation and you're the one making those decisions for yourself. So just keep in mind, if you want to bring a boyfriend, girlfriend, family friend, the opposing side does have to agree to that first. And if they don't agree, then you have to handle it solo. But you'll have your attorney there to guide you. So it's not going to be as scary as a process as it sounds, especially if your attorney has prepared you in advance for what to expect and has defined those terms. And so you know what the attorneys are talking about in the mediation.
Yes. Well, you brought up a good point about Zoom, that it could be wherever they're most comfortable.
Absolutely.
Some people are not comfortable with technology, so they would rather not do the Zoom from their home because they're nervous about it working and nobody would be there to make it work. And so in those instances, sometimes they go to their lawyer's office.
Right.
But I've had other cases where somebody said, if I hadn't been at home and been able to hold my dog, I never would have been able to settle this. So that was surprising to me. I had never thought about that before, that this is so personal and emotional, that having an emotional support like your dog, like your own food, like your own, I mean, it's a long day, that could really help somebody to have a more successful day. So I really think it just depends on the case.
Absolutely.
I have people who feel strongly they want to be in person. I like being in person, connecting with another human being.
Agree.
And I was worried. We had to start doing it via Zoom when COVID hit.
Yeah.
And I was worried. I thought, oh, how am I going to connect with people over the internet? But I agree with you. It's equally successful, and in some instances, probably more successful. If there's any type of safety concern,
Oh, 100%.
it's so nice to not be in the same facility, where even though we keep them in separate rooms, they still are parking in the same parking garage, things like that. So they might run into each other in the hall. So any cases where there's family violence history, safety concern, Zoom is such a great option.
Absolutely. I would 100% agree with that. And again, if there's a safety concern, Your attorney would probably know that, but alert your attorney to that fact so mediation can be conducted around those parameters to ensure your safety.
And you mentioned the privacy, that we can't have third parties.
Yes.
And sometimes with the Zoom, people try to be tricky
Yes. I've
and
seen
they
it
hide
happen.
the person. But eventually I see them and then
Yes.
I'm furious because I always ask them to give me their word that no one else will be in the room. Of course, someone else could be in the house, but if they enter, I rely on that person to alert me. They can be talking to the third party when I'm not in the room. When the mediator is not in the room,
Correct.
they could talk to the third party.
Yes.
But when I come in, the third party needs to vacate the premises.
Yes. Absolutely. Absolutely. I agree with that. And again, just keep in mind that this is your family. These are your assets. These are your liabilities. So it's very important that you understand and take reign over that decision making, because at the end of the day, you're the one that has to live with those consequences.
Yes, I think it's important to help our clients be educated and mentally, emotionally prepared to make good decisions for themselves.
Absolutely. That's a role of an attorney at mediation for sure, if not the main role at
Mhm.
mediation for an attorney.
Thank you so much for being here. I think
you
this
for
is good
having me.
information. Hopefully, we'll have even better mediations in the future. 'Cause
Fingers
people
crossed.
will be prepared.
Yes, absolutely.
I really appreciate it. Vanessa, tell just 2 seconds about your practice. And I know you're in our Dallas office, but where all do you cover in the Metroplex?
So I cover pretty much the metroplex. I cover
Mhm.
Collin, Tarrant, Denton, Rockwall, Dallas, obviously, and
Mhm.
Collins. So I'm all over the place. So, and it's obviously my goal in representing a client is to get the best deal for them, be it via litigation or the settlement process and mediation. So it depends on your case, your goals, your aspirations, but just know I'm listening to that, and we're going to navigate your case in the best way possible to achieve those goals.
And one fun fact about you is you speak Spanish.
I do. I'm fluent in Spanish. My mom is from Chile, which is a country in South America. But yes, I'm fluent in Spanish. So I definitely appreciate my mom teaching me that when I was a child.
Oh, that's wonderful. Well, thank you so much for being here.
Thank you, Melinda, for having me. It
You're
was so
welcome.
fun.
And thank you for watching. Please tune in again next time.